constitutional law question from February of 2005 is a straightforward and easy question if you know the law. This is one of those hypotheticals that's about as short as many multi-state questions. And it's also a fact pattern that doesn't require us to scratch our head and do a whole lot of thinking about what the issues are. Take a look with me at the call of the question. Can Oilco successfully assert that the statute violates any of the following provisions of the U.S. Constitution? 1. The Commerce Clause. 2. The Equal Protection Clause. 3. The Due Process Clause. And 4. The Privileges and Immunities Clause. Discuss. Well, all we need to do is set out our four-part outline and then do as much as we can to flesh it out before we begin to write. So let's think for a moment. Without even reading the fact pattern, we know that the Commerce Clause is a fairly complicated yet straightforward statute. We can look to see whether or not a statute unduly burdens interstate commerce or if it unreasonably discriminates between states. With regard to the Equal Protection Clause, once again, we are looking for some sort of unconstitutional discrimination. With regard to the Due Process Clause, notice that they don't specify which due process clause. So we'll talk about them both, procedural and substantive due process. Then, finally, the Privileges and Immunities Clause. Well, we can answer this question without even reading the fact pattern. Can some entity called Oilco successfully assert something having to do with the Privileges and Immunities Clause? Answer, no, because the Privileges and Immunities Clause doesn't apply to business entities, only to flesh and blood citizens. So, once again, we've got a question here which is much more akin to the multi-state than to the essays. Except we've got 1 hour to craft an answer to this question, as opposed to merely 1.8 or a couple of minutes to answer a multi-state question. So go to the top of the question with me, and we've got only 3 paragraphs to have a look at. You know, often these are the most difficult questions. But here, since they spoon-feed us the issues, our job is to make the most of everything that they give us. So at the top of the question, we find out about this statute. The statute in State X prohibits the retail sale of gasoline that does not have 10% of ethanol in it. And so we call the entire product gasohol. The statute is based on specific legislative findings, 3 specific ones, and we're going to have to discuss each of these in a reasonable amount of depth, one place or another in our answer. So the first justification is petroleum savings. The second justification is environmental. It burns more cleanly. And then the third finding is using more gasohol will help the grain-growing regions in State X. And State X is one of those grain-growing regions. In paragraph 2, we find out that detail about State X being the largest grain producer for ethanol. And then we meet Oilco in paragraph 3. Oilco is a transnational corporation doing business in State X. They're a big gasoline supplier, and Oilco doesn't dispute any of the legislative findings, but Oilco also wants to maximize its profits, and it would just as soon find a way around compliance with this statute. We also see that the oil company's profits have apparently been harmed as a result of this statute. So now we get the call of the question again, and we have to pause again for a moment and carefully consider how we're going to craft an answer to this question. It is so short, and the questions presented are so specific that here, rather than having to rely on technique to come up with the issues, we have to use a somewhat different set of techniques to get the absolute greatest value for our analysis. So turn the page with me and have a look at the outline of issues that I've presented. You'll see that basically all I'm doing is I'm following the call of the question. But first, I discuss the preliminary issues, standing, ripeness and mootness, state action, and the 11th Amendment. and it's possible to organize this preliminary material in a couple of different ways. Clearly, the real heart of the exercise is answering the call of the question. But we present these threshold issues because they are germane to the analysis and because leaving them out would render our answer noticeably less complete. Then, as we focus on each of the constitutional issues, you see that I am not doing much more than I was able to figure out at the time that I read the call of the question. Before even starting to read the fact pattern, with regard to the Commerce Clause, I have a section on discrimination, a section on undue burden, and then I reach a conclusion. Now, pause for a moment. This Commerce Clause issue is fairly technical, and as you think about it and review the facts in the pattern, one thing I think you'll agree about is this is a fairly close call. Both sides have got very good Commerce Clause arguments. So this is a situation in which it doesn't really matter what your conclusion is. What matters is how thoughtful and how in-depth your analysis is. Now, as it turns out, I find that the statute does not violate the Commerce Clause. Well, that's just my opinion. You don't have to agree with me at all. But what you do need to do is spot the issue, break it up into some sensible organization, and then apply the facts before you reach a conclusion. Now, if you are a scholar in the Commerce Clause, as you have a look at my answer, you'll see that what I've done is sensible, rational, reasonably complete, but it's hardly scholarly. If you know a great deal about the Commerce Clause, you might be tempted to answer this part of your section somewhat differently, and that's entirely fine. However, the risk of doing a really scholarly job on the Commerce Clause is that it would take so much time that you would be unable to complete the rest of the question, as well as you would do if you made the Commerce Clause analysis just a little bit more simple. Next, I turn to the Equal Protection Clause. Here again, at the outline stage, all I do is discuss whatever discrimination the plaintiff might be able to point to. Then I apply the appropriate review standard, and then I reach a conclusion. With regard to due process, I've got one section on procedural, one section on substantive, and then I reach a conclusion. The Privileges and Immunities Clause issue is so simple and straightforward that I don't even choose to break it down internally. Perhaps one could, but I don't think it's necessary. Then, finally, I reach a global conclusion that presents an answer to the question as a whole. Fair enough. Now take a look at the model answer that I've provided. This is well worth taking a few minutes to have a careful look at. Because here, the technique that I'm illustrating for you is not how to spot the issues when it's tricky to spot issues. The techniques that I'm presenting here are how to analyze the law and the facts at a greater depth as a result of the luxury of time. So, right up front, as usual, I lead with the facts. I explain who the plaintiff is. I talk about Oil Co. for a sentence. Then I talk about the State X statute. And then I indicate that Oil Co. has got constitutional law issues. First we get into standing, ripeness and mootness, and here you'll see I even managed to work in a little bit of corporations law, indicating that Oil Co. is doing business in State X, and I discuss the fact that a state qualified corporation has got access to the courts. Now, is that an essential issue? Of course not. But it is a way of finding a home for that specific fact and then interpreting it in a way that grounds our discussion of the facts in an appropriate legal context. I indicate exactly why Oil Co. has standing, because of the impact that the statute has had on its profits. Then we turn to state action and the 11th Amendment. Here, again, there's nothing complicated going on. And you'll also notice I don't spend a great deal of time on any of these threshold issues. At the same time, you'll see I don't really leave anything out either. I'm getting to the point, finding a home for the details, analyzing the facts with regard to the law, and then moving on. So now we turn to the Commerce Clause. And this is the most elaborate part of the question, and it's also the most complicated part of our model answer here. So Now take a look at the first couple of paragraphs of that analysis. Right up front, I explain what the Commerce Clause is, and then I go into a little bit of depth about what OilCo has to show in order to prove its constitutional claim under the Commerce Clause. I start out by considering the alleged discrimination, and you'll see that I go really into quite a bit of depth about it. And the problem that I have with OilCo's discrimination claim is it hasn't really been singled out in the way that we traditionally think of as justifying a Commerce Clause claim. Turning to the undue burden argument, this is the stronger argument in my judgment. And if you're going to disagree with me about the constitutionality of this statute, more likely than not, it would be because you disagree with me about whether or not the statute constitutes an undue burden on interstate commerce. And you'll see, as I go into the analysis, once again I lead with the facts, and then I manipulate the facts with regard to the law. Ultimately, I conclude in favor of the statute. But even I acknowledge that it's really a fairly close call. One could very easily argue the same material to reach the opposite conclusion. That's why we have an adversarial system. Oftentimes, both sides have fairly compelling arguments, and we come to court to resolve them. Finally, I conclude in favor of the statute with regard to the Commerce Clause, and then move on to consider the Equal Protection Clause. Up front, I explain what that clause is, what it's intended to do. Then, the actual analysis itself is pretty short and straightforward here, because OilCo can't prove that it has been discriminated against. This is not a plaintiff that has somehow been targeted for discrimination. So I apply the rational basis test to this statute. I find in favor of the state. Yet again, moving on to due process. We know that there are two different types of due process. We know that the call of the question doesn't specify one over the other. So it's our job to consider both. And I do so in a fairly concise couple of paragraphs each, and I conclude that the statute doesn't violate the due process clause. The procedure appears to be reasonable, and there are no fundamental rights at stake that would trigger a full substantive due process analysis. So I conclude in favor of the statute yet again. Finally, we turn to the Privileges and Immunities Clause. And here, I have virtually nothing to say about it beyond what I was able to come up with right at the moment of looking at the call of the question. The Privileges and Immunities Clause is a protection afforded flesh and blood citizens, not corporate citizens. So, taken as a whole, my judgment is that OilCo's constitutional claims all will fail. Once again, you don't necessarily have to agree with me, but I think you will agree that you have to structure your answer in such a fashion as to fully present the various issues. And you've got to write your answer in such a fashion as to find a home for all of the facts.